Right, well, good morning, and thank you for coming along and almost filling this room, which is quite a surprise to me, but a pleasure notwithstanding. And I'm Paul Parker. I'm going to talk to you about inappropriate behaviour in the workplace and what to do about it. I'm specifically going to focus upon your workplace and what the SRA is up to, if at all, on the subject. When I first started giving lectures on the SRA standards and regulations, or the Code of Conduct as we more conventionally call it, I noted that despite the relative brevity of the two codes of conduct with which we're now all familiar, that brevity was somewhat offset by the SRA guidance publications, then some 58 or so in number, with accompanying topic guides, case studies, and a lengthy enforcement strategy document, which all had the effect of padding up the rules quite nicely. Now that padding has carried out a pace, so that by my most recent count, there are now 102 separate pieces of guidance on the SRA website, along with 15 warning notices and 24 case studies. And there's no shortage of other information in other sections of that website too. Now my focus today is going to be concerned with only one small corner of that website, and that to do with workplace cultures, and in particular the extent to which the SRA claims to be interested in the workplace environment that you, depending on your role in the firm, are either going to be providing or being the beneficiary of, and the types of issues that the SRA might be most interested in, what you can and should do to call out inappropriate behaviour, and the extent to which the SRA is in fact becoming involved in matters to do with your workplace environment. Now, you won't be surprised to know that the vast majority of cases that have become the subject of regulatory settlement agreements or decisions of the SRA and judgments of the SDT have in the last 5 or so years concerned sexual misconduct. And though I shall mention some of these, which will be concerned exclusively with events inside the workplace environment during the course of this morning, you will learn more about the SRA's reach into such matters if you come back into this room at 12:45 to listen to Claire Dixon and Ben Smiley talking about regulation of lawyers for sexual misconduct and inappropriate use of social media. The other thing that to mention at this stage is that today's talk is not intended to be and will not be a talk on employment law, although concepts familiar to employment lawyers, and I'm not one, will come into it. We'll encounter in a short while the slightly curious case of Bhatia, in which the SDT found itself considering a finding of discrimination against the respondent in the context of disciplinary proceedings. For the interplay between matters before the Employment Tribunal, the ET, and matters before the SDT, is something that practitioners in regulatory and disciplinary law seem to me to be increasingly likely to meet in practice. I say this because of what I read in a joint statement from the SRA and the SDT on referrals to the SDT, which was issued just over a year ago on the 30th of January 2023. The joint statement was issued in the light of the Ministry of Justice's increase to the SRA's fining powers from £2,000 to £25,000 for solicitors and traditional law firms that had occurred in July 2022. This considerable increase in what the SRA could do was seen in some circles as damaging the independence of the process by which errant solicitors might be brought to heel, inasmuch as the SRA, as traditionally investigator and prosecutor, was now given far more impactful powers to act as judge and jury as well. It was important then to make clear that the SDT was to continue to have a vital role in the regulatory and disciplinary process, and so the joint statement identified the cases that would continue typically to be referred to the SDT despite the SRA's wider fining powers. The joint statement gave the following examples of cases that would best be heard by the tribunal. Cases involving allegations of sexual misconduct, racism, bullying, harassment, or other counter-inclusive misconduct and or conduct that targets an individual, for example, where there is evidence of a target because of a protected characteristic, and a failure by a law firm to take appropriate steps to protect an employee from counter-inclusive misconduct, or to ensure a safe working environment, for example, where there's evidence of a pervasive toxic culture. There are obviously other matters that are fit for the SDT exclusively, cases of high public interest, serious failures to comply with regulatory framework, cases involving manifest incompetence, recklessness, dishonesty, and other matters of that type. But of course, it's the misconduct, racism, bullying, harassment, counter-inclusive misconduct issues that we're concerned with today. Now, two expressions used in the passages that you see on the screen behind me, I should say, need particular mention. The first is counter-inclusive misconduct. The emphasis on this aspect of lawyers' behaviour derives from a statement from the Legal Services Board in May 2022, signed by all legal services regulators, SRA, Bar Standards Board, SILEX, and a whole host of others, as well as BTAS and the SDT, stating as follows, and I quote, "Counter-inclusive misconduct, which is conduct which intentionally or unintentionally has the effect of narrowing or denying opportunities to people because of their background or circumstances, is serious and will be challenged and dealt with appropriately. We will take every opportunity to ensure that its seriousness is reflected in a consistent way within our standards and codes and in our approaches to disciplinary action. We will support each other in ensuring a consistent message to promote understanding across the whole sector that counter-inclusive misconduct and behaviour must and will be tackled effectively wherever it is found." Close quote. So that's the first expression that we need to be familiar with. And the second is pervasive toxic culture. Now, pervasive toxic culture is a concept that the SDT encountered most notably towards the end of the last decade, then being deployed not as a regulatory sword, but as a defensive shield in cases where solicitors, often but not always the most junior, sought to avoid being struck off for dishonesty on the basis that pressure of work or extreme working conditions made them do it. Now, the best known case is the one of Savani James. And to remind you of that one, I'll quote from paragraphs 4, 8 and 113 of the judgment of Lord Justice Flo in the Administrative Court. Between August 2013 and January 2015, she made a series of misleading statements on 9 separate occasions to the client and to the firm about the current position on the file, giving the impression that certain proceedings had been stayed, judgment on liability had been obtained in the client's favour, and extensions of time for service of the schedule of loss and medical report had been granted by the NHS Trust. None of this was true. The SDT found that the firm was a challenging place to work. It was seeking external investment, which would bring time recording and billing under scrutiny. The senior management sought to pass pressure onto junior staff, such as Miss James, with monthly publication of league tables to create competition between fee earners. The SDT was particularly critical of an email from a senior manager in July 2012 complaining about a shortfall of Miss James's billed hours against her target, and a letter from the senior partner to Miss James in April 2013 requiring her to work evenings, weekends and bank holidays to make up chargeable hours. The SDT found that this was, quote, "a notable example of bad, ineffective and inappropriate management." I'd rather describe that as rather worse than that, but there we are. Pausing there, I'm unaware of any disciplinary proceedings being instigated against that firm, notwithstanding those remarks from the SDT, nor these that I'm just about to quote from the court. Lord Justice Flo said, "Pressure of work or extreme working conditions, whilst obviously relevant by way of mitigation to the assessment which the SDT has to make in determining the appropriate sanction, cannot alone or in conjunction with stress or depression amount to exceptional circumstances. Pressure of work or of working conditions cannot ever justify dishonesty by a solicitor. It may be that pressure of work or an aggressive, uncaring workplace could excuse carelessness by a solicitor or a lapse of concentration or making a mistake, but dishonesty of any kind is a completely different and more serious matter involving conscious and deliberate wrongdoing. It doesn't seem to me that this point is altered by the fact that, at least in one of these cases, James, the pressure on the respondent was caused in large part by a culture in the firm which was toxic and uncaring. That might provide an explanation for her dishonesty having occurred, but it cannot excuse it and therefore cannot amount to exceptional circumstances justifying a lesser sanction. Now, the case of Emily Scott, the third respondent in the next case on the slide, took a slightly different course. Whilst a trainee, she was alleged to have raised bills of costs for work that she knew hadn't been done, drew down funds from a legal funding loan using a document which she knew bore forged signatures, and falsified a client file for the purposes of a legal ombudsman investigation. Her defence was, to quote her, such actions were only done under the instruction of my supervising partner, and again, I was not given an option. It was a case of do as you are told or lose your job and any chance of qualifying as a solicitor. As things turned out, she was found guilty only in respect of the third of these charges, the SDT, which was falsifying a file in the LEO investigation. The SDT commenting as follows, and I quote, "The tribunal also noted that the third respondent had a means of extricating herself from the situation, albeit one which may not have been appealing, and she had chosen not to avail herself of those options. These could have included making a report to the SRA or to the CULP much earlier. The fabrication of the documents took place over a period of in excess of 4 months, and her report to the SRA about these matters did not follow for a further 6 months, despite the fact that she was nearing the end of her training contract. The difficult circumstances in which the third respondent undoubtedly found herself were not of the order of severity or of immediacy that could justify her falsification of a client's file over a period of months. The tribunal was satisfied beyond reasonable doubt that, notwithstanding the unpleasant working environment in which she was operating, her actions would nevertheless be considered dishonest by the standards of ordinary decent people." Now, on the facts, and in the light of the James decision, that was hardly a surprising conclusion. But what does seem to emerge with some clarity from that case is that where a junior solicitor is ordered to do something dishonest, he or she is caught between the rock of reporting the matter and being fired, and the hard place of doing as told and then being struck off if found out. And if it weren't clear enough from those remarks of the SDT that its preferred course would have been for her to have reported the firm, then the fact that she was also charged with failing to self-report and report the firm more or less immediately reinforced the point, as to which the tribunal held as follows, and again I quote, "It was a fact that she had not reported the matter to the SRA until January 2015, having made a report to the CULP in November 2014. The central question was whether the report had been made promptly. The misconduct on the part of the partner that she was aware of stretched back more than a year, and in some cases nearly 2 years. The misconduct in question was extremely serious and therefore called for reporting at the very earliest opportunity. The tribunal noted and accepted her submissions about the pressures she was under. The situation in which she had found herself may well amount to mitigation, but it was not a defence to an allegation of lack of integrity." But, as we know, a proven lack of integrity is not significantly less a threat to one's remaining on the roll than a finding of dishonesty. Indeed, if I'm not much mistaken, if you go to David Turner and Connor Ewan's talk in the Linda boardroom immediately after this one at 11:45, you may be told that there is no difference between the two. Although that is this is a viewpoint with which I disagree fundamentally. Anyway, there we are. And what? Yes, thank you. Good. Tell that to David and Connor later. The third of this trilogy of cases, Sheehan, concerned a far more senior solicitor. Over the course of 2 years, she moved from firm A to firm B, and then, having found things unsatisfactory at firm B, made overtures to move to firm C. It transpired that she had overstated her financial performance at firm A in order successfully to persuade firm B to admit her into the partnership. Then at firm B, she found herself under intolerable pressure to generate fee income, and so sought to move away into a more personally sustainable position. Unfortunately, in applying to join firm C, she again deliberately misrepresented her schedule of hours and billings. she was struck off. Reassuringly, perhaps, the SDT's judgment contained this passage, and again I quote, "The tribunal was mindful, however, of the evident pressures placed upon partners to meet billing targets, and also an observation regarding the importance for firms to ensure the well-being of their partners in the light of these relentless pressures." Which comment, as in James and Scott, seems to be signalling that the profession's regulators are becoming aware of the relationship between misconduct and a pervasive toxic culture, even if by then still none of the perpetrators of that culture were finding themselves in the disciplinary dock. So what the SRA did do was to conduct what it called a workplace culture thematic review, which it published in February 2022. It gathered views from the Chief Executive of Law Care, the Chair of the Junior Lawyers Division of the Law Society, hundreds of solicitors and a dozen or so law firms of various sizes from small to large. Its mission was to research the profession's responses to workplace challenges that may impact on firms' and individuals' ability to comply with the Code of Conduct, and described it thus in the introduction to the very Code of Conduct. The Code of Conduct describes the standards of professionalism that we, the SRA, and the public expect of individuals, solicitors, registered European lawyers and registered foreign lawyers, authorised by us to provide legal services. They apply to conduct and behaviour relating to your practice and comprise, and these are the important words, a framework for ethical and competent practice which applies irrespective of your role or the environment or the organisation in which you work. The review then set out what it concluded was to be expected of the profession in the following terms, the briefer summary of which appears on the slide. I'll read you the full text. We expect firms to create and maintain the right culture and environment for the delivery of competent and ethical legal services to clients with effective systems, supervision arrangements, processes and controls in place. This includes taking steps to run businesses in a way that supports well-being by minimising the risk of working practices and workplace behaviours leading to poor mental health. A failure to put in place systems that protect employees may lead to an increased risk of breaching our regulatory requirements. Lawyers need good mental health to deliver what can be a challenging role in clients' best interests. Being able to speak out about mental health difficulties and supporting employees at an early stage could prevent concerns and issues escalating. It can also support firms to minimise risks such as reputational damage. If employees are not adequately supported to manage mistakes or to manage client demands, they may be at risk of behaving unethically. If mistakes are made, you should be open and honest with clients if they are affected and explain promptly what happened and any consequences. We will always look at the context of misconduct and try to understand any wider mitigating or aggravating factors that may have contributed towards any issues. We also expect you to report any matters you reasonably believe could amount to a serious breach of standards and requirements. Our enforcement strategy explains more about your obligations to report concerns to us and other legal regulators. I'll come back to that in a short while. Finally, firms should encourage equality of opportunity, equal treatment and respect for diversity so that employers are treated fairly at work. Prevent fair and inappropriate treatment by doing everything you reasonably can to protect employees from bullying, harassment, discrimination and victimisation. I'm sure you'll all agree with me. These are fine words and laudable aims. They have more recently been backed up by updates to the Codes of Conduct, accompanied by a guidance document called Workplace Environment, Risks of Failing to Protect and Support Colleagues, which was first issued at the time of the thematic review and updated in May 2023. And we'll have a little look at that a little bit more closely in a moment. The updates to the Codes of Conduct, which you see on the slide behind me, puzzlingly you may think, came at different times depending on which code it was being updated, solicitors or firms, but essentially seek as pithily as possible to embody what was said to be expected of the profession in the review. And you'll see from the passages on the slide that there are a number of concepts that might merit some elucidation. The phrase, treating colleagues fairly and with respect. The word colleagues itself, And then the words bullying, harassment, discrimination, victimization, and the requirement to challenge behaviours. So, let's take these in turn. Treating colleagues fairly and with respect. The SRA says this: our enforcement strategy explains that we will not take action on every breach. We focus our action on the issues that are most serious, either in isolation or because they demonstrate a persistent failure to comply or a concerning pattern of behaviour. When considering whether any unfair treatment is serious, things we will take into account include whether the behaviour could reasonably be seen by others as intended to bully, belittle, harass, intimidate, undermine, or take advantage of colleagues. They will include the respective seniority of those involved and factors such as whether an individual has control or influence over another's career. They will include whether individuals have specific characteristics or vulnerabilities, for instance in relation to age, sex, disability or ethnicity, particularly if this appears to have been a factor in the behaviour complained of. So who are your colleagues? The word colleagues, they say, not only refers to people who are formally employed by the firm or organisation in which a solicitor works, but others with whom the solicitor works closely, such as contractors, consultants, experts who may be instructed by the firm, and, yes, barristers, which is good news. So, yeah, be careful. And what does bullying mean? Well, there is no legal definition of bullying. So the SRA say this: we and other regulators consider bullying to include unwanted behaviour that is either offensive, intimidating, malicious or insulting, or an abuse or misuse of power that undermines, humiliates, or causes physical, emotional, or emotional harm to someone. And that bullying can be a regular pattern of behaviour or a one-off incident. It can happen face-to-face or remotely. And of course, the judgment call is determining where the line should be drawn between legitimate criticism of someone's work and actually having a go on the other side of the line.
Did they say whether it's an objective or a subjective?
Well, we'll come to objective and subjective in a moment in terms of in terms of reporting obligations, but no, beyond that they don't. There's no decision on that at the moment either, so we don't know. But so far as identifying what bullying actually might amount to, it strikes me very much that it's one of those things like the mythical elephant that I've never really quite understood, that it's easier to recognise than to define. So that's bullying. Then we got harassment, discrimination and victimisation, and they all take their meanings from the Equality Act. Harassment is unwanted conduct relevant to a protective characteristic, and the protective characteristics, as I'm sure some of us may remember, are age, disability, gender reassignment, race, religion or belief, sex and sexual orientation, and there's one other. No, I can't remember. Anyway, which violate the victim's dignity or create an intimidating, hostile, degrading or humiliating offensive environment for them. Discrimination is treating someone less favourably than others on account of their protective characteristic, age, disability, gender reassignment, race, religion or belief, sex and sexual orientation. And victimisation is subjecting someone to a detriment because they have done or are believed to be doing a protected act. These being, and a list is provided in the Equality Act, bringing proceedings under the Equality Act, giving evidence in such proceedings, or making an allegation that someone has contravened the Equality Act. Although not necessarily related to the Equality Act, it is difficult to see how treating an employee disfavourably because they're contemplating a report of misconduct to the SRA, or in fact making such a report, can be anything other than victimisation in the eyes of the SRA or the SDT. Now, what about the obligation to challenge behaviours which are discriminatory or amount to bullying or harassment? The guidance here is directed towards the firm's managers and requires them to take action to address the relevant behaviour. Unhelpfully, you may think, the guidance continues, we do not prescribe how this should be done, and the action does not necessarily need to be formal, but it should be effective. So, in other words, the guidance says, do something. We don't really care what you do, but make sure it works. And they might as well have just said it in those terms. So, then, much of what follows in the guidance is in the category of what might be described as the bleeding obvious. If you see it, stop it. Speak to the person involved, raise it with your culp or partner director or director responsible for HR, and make a record of the incident. But what of reporting the matter to the SRA? Right, well, the starting point is paragraph 7.7 and 7.8 of the Code of Conduct for Solicitors. 7.7 says, you report promptly to the SRA or other approved regulator as appropriate any facts or matters that you reasonably believe are capable of amounting to a serious breach of their regulatory arrangements by any person regulated by them, including you. And notwithstanding paragraph 7.7, 7.8 continues, you inform the SRA promptly of any facts or matters that you reasonably believe should be brought to its attention in order that it may investigate whether a serious breach of its regulatory arrangements has occurred or otherwise exercises regulatory powers. So two questions arise on this wording. First, what is the test of belief as to seriousness? And that is going to impinge upon your point. And second, what is a serious breach? As for the test of belief, it is instructive to remind ourselves of the, I think quite notorious at the time, case of Gary Senior. He was the managing partner of a large practice who, after a graduate recruitment event, invited colleagues back to his hotel room to raid the minibar. And once the minibar was empty and his colleagues were leaving, he used a pretext to keep a junior female employee behind, whereupon he sought to initiate intimate physical contact and he kissed her. For that and other behaviours during the internal investigation of his conduct, he was fined £55,000 by the SDT and had an award of costs made against him in sum of about £48,000. Quite an expensive kiss. However, also he and the firm as a whole, and the partner who'd conducted the investigation, and the director of HR, were charged with not reporting the matter to the SRA. Now, the relevant reporting obligation was worded differently in the 2011 Code of Conduct, which was the applicable code for these particular events. And the SDT decided that the then test for determining whether the relevant conduct was serious was a subjective test. The respondents managed to persuade the tribunal that they had all genuinely believed that Mr. Senior's conduct had not been serious enough to be reportable. I can hear jaws dropping, but there we go. The tribunal held in terms that the respondent's state of knowledge did not have to be reasonable, it merely had to be genuine. Now, it's impossible, it seems to me, to see how that decision would have been the same under the present day wording, which requires reasonable belief. In other words, not only that the belief is genuinely held, which is a subjective element, but also that the reasonable person in the solicitor's position would hold the same belief. In other words, the objective test. And it's that objective element to the test, it seems to me, that will now increase the likelihood of matters being regarded as reportable. The breach, however, still needs to be a serious one. And on seriousness, the Code of Conduct and all accompanying guidance fails to provide a definition or even clear parameters. There is specific guidance on reporting and notification obligations, that's the title, Reporting and Notification Obligations, that was published in November 2019, but it refuses to be drawn on seriousness. So perhaps the best working guide is to be found in the SRA enforcement strategy, most recently updated in February 2023. That doesn't form part of the Code of Conduct per se, but it does send a message on how the SRA seeks to go about its regulatory obligations, and so merits a careful read. The SRA's starting point is the nature of the allegation. It says, I quote, we see certain types of allegations as inherently more serious than others. For example, we will always take seriously allegations of abuse of trust, taking unfair advantage of clients or others, and the misuse of client money, as we will sexual and violent misconduct, dishonesty, discrimination, harassment, and criminal behaviour. It then goes on to list common factors that, quotes, affect the view we take of how serious an allegation is. These are, firstly, intent and motivation. The SRA is unlikely to take action in the case of an isolated, genuine mistake, unless that mistake was manifestly incompetent. But deliberate or reckless disregard for one's obligations, dishonesty, lack of integrity, premeditation, and/or persistence will elevate an incident into a serious one. Harm and impact. The nature and level of harm caused by the error will be a relevant consideration. But there will also be cases where, although no harm in fact had presented, there was a real risk of harm. And the greater the risk, the greater the chances of the relevant conduct being classed as serious. Next, vulnerability. A vulnerability on the part of the client may be a relevant factor. As explained in the enforcement strategy, this may be because, I quote, the solicitor took advantage of the person's vulnerability to, for example, provide misleading information, or of the raised awareness that the solicitor should have had about the need, for example, to communicate effectively or ensure that the client is in a position to protect their own rights, or of any enhanced impact on the client as a result of their vulnerability, which the solicitor could and should have anticipated. Next, role, experience, and seniority. The SRA takes a view that those with more seniority and experience should have higher levels of insight, foresight, more knowledge, and better judgment. It should therefore logically follow that the more senior a practitioner is, the greater the chance of his or her error being regarded as serious. Now, this is, I think, to be contrasted with the position in general professional negligence law, which focuses more on the specialism within which the practitioner is working, rather than the individual's senior or junior status. And there is a distinction, I think, that one can see there. And then finally, regulatory history and patterns of behaviour. The SRA will be more likely to ascribe seriousness to behaviours that are repeated or behaviours within a firm which show a propensity not to learn lessons. A breach which falls into the category, oh no, this has happened again, is much more likely to be reportable as serious than it may have been the very first time it occurred. Reportability turned out to be the issue in the Bhatia case, which you now see on the slide, which I mentioned earlier in this talk. Mr. Bhatia's firm had employed a Miss Brown as a paralegal in its family department, but then she was dismissed. So she took the firm to the ET and won compensation because it was held that she had been discriminated against on the grounds of pregnancy and maternity. The story was then reported in the local newspaper and thus came to the attention of the SRA. So disciplinary proceedings were brought against Mr. Bhatia, both on the basis that he had discriminated against Miss Brown and that he'd not reported the fact of the ET judgment to the SRA. This is the only discrimination case that I've been able to find that had been run in the SDT, and it failed. The SDT took the view, justifiably, that it had to make up its own mind about the discrimination allegations, but it came to a different conclusion from the ET. The SDT wasn't bound to follow the ET, but it is perhaps a little surprising that the SDT didn't pay greater heed to the findings of what is, after all, a specialist tribunal. Nevertheless, there was in existence still a judgment of the Employment Tribunal extant against the firm, in which the firm had been found guilty of discrimination. The SDT had no hesitation in concluding that that adverse judgment should have been reported to the SRA. Now, at first blush, you might think that it's odd to require a solicitor to self-report something of which his regulator's disciplinary body concludes he didn't do. But of course, reportability and the ultimate merits are two different things. It's one thing for a solicitor to say, I've been found guilty by a tribunal, but I don't accept that I did anything wrong, and therefore I have nothing to report. And another thing to say, I've been found guilty by a tribunal, I don't accept I did anything wrong, but the adverse decision does look serious, so I must report it, and then I'll go on to demonstrate why it's wrong. And that's the difference. And that latter course is obviously the right course. So, where does that all take us? The guidance tells us that the SRA will, quote, focus on breaches that are particularly serious in isolation, or which demonstrate a persistent failure to comply, or a concerning pattern of behaviour. Therefore, in relation to individuals or firms, or a one-off complaint, for example, due to a single episode of bullying, is unlikely to lead to regulatory action. But we are likely to take action against an individual where, for instance, there is evidence of behaviours which intentionally undermine, bully or harass a colleague or which are discriminatory, repeated or blatant unfair treatment of colleagues which leads to culture, practices or actions which are unethical or against the interests of clients, intentionally placing pressure on a person to act improperly or victimising them for acting properly, or a manager failing to challenge or address any such behaviour in a prompt or effective way. And as for firms, the SRA says we are likely to take action against a firm where, for example, there is evidence of a pattern of the abuse of authority by senior staff that has been left unchecked by the firm, a complaint of discrimination, victimisation or harassment not dealt with by the firm in a prompt and fair manner, complaints of bullying raised with the firm over a period of time involving a number of staff and inadequate action taken by the firm as a result, or evidence that the incidents had not been brought to light sooner because of the firm's culture and or inadequate reporting and disciplinary procedures, a history of the firm's managers failing to challenge the unfair treatment of staff in a reasonably prompt or effective way, a firm pressurising staff to withdraw their complaints, ineffective systems and controls including failure to supervise or support staff leading to serious competence or performance issues or delivery failures, and the imposition of wholly unreasonable workloads or targets, which of course takes us back to those pervasive toxic culture cases that we looked at the outset of this talk. So, and you can also see now how those policies have been derived, at least in part, from some of the material that we've been looking at this morning. Now, I thought I'd conclude by giving you a taste of some of the recent cases that have been decided either by the SRA pursuant to its new enhanced powers or by the SDT over the last year or two. It's fair to say that most, if not quite all of them, have varying degrees of a sexual element at their heart. And those are the nature of the cases which are currently running through the SRA's hands and through the SDT. But as I say, there are new issues now that those two bodies will be increasingly interested in. So, Walmsley, he took clients and staff to what turned out, unbeknownst to him, to be a kind of strip club. And the complainant was rather embarrassed to be there. All the more so when he put his arm around her in an avuncular and non-sexual way whilst at the club. A report to the SRA resulted in a rebuke for the respondent and an express recognition by him that once he had recognised the calibre of the club that they'd entered, he should have taken reasonable steps to ensure that she wasn't uncomfortable and to ensure her well-being and to ensure that his actions didn't exacerbate her feelings at being present in the venue. Conway was off his face at the staff Christmas party and made unwanted sexual contact and other threatening physical contact on two colleagues. Unusually, in such cases, in the cold light of morning, he self-reported. He was fined £2,000. Sims, on and off over a period of some 3 years, Sims indulged in some inappropriate messaging with a colleague, made unwelcome comments about her sex life, and was guilty of one incident of inappropriate touching. After an internal investigation, the matter was finally reported to the SRA some 5 years after the first incident. He was rebuked, but he agreed to remove himself voluntarily from the role for a minimum of 3 years. Thorne made a lewd gesture to his female colleague at the office Christmas party, which was captured on video footage. For this, he was rebuked by the SRA. Cartwright had had an inappropriate at-work relationship, the details of which are not reported. But when investigated about it, he denied the relationship and told other lies. He agreed to remove himself from the role and not return to the profession. Charkham used racially abusive language to a staff member on one occasion and racially offensive conduct on another. He put a large A4 size envelope on his head and said, "I'm a member of the Ku Klux Klan." Wasn't clever. Anyway, both of which he wrongly characterised as banter, and was guilty of sexual touching of that same complainant on several occasions and of another complainant on another occasion. The SDT fined him £30,000 and sent him on an equality and diversity course. AC, who managed to get an anonymity order in his favour, and if you want to know why, I think Claire Dixon was in that one, so you can ask her. At the firm's Christmas party, he sang a song with vulgar words and gestures directed to one particular complainant with whom he'd maintained a course of unwelcome flirtatious behaviour over the following year. These matters came to light in the course of her wider employment grievance for ultimately being overlooked for a job at the end of her training contract. And for that conduct, he was fined £23,000. Unwosu asked the complainant a series of impertinent sexually motivated questions during her job interview. She complained. He was fined £20,000, which the administrative court upheld on appeal, whilst commenting that the sanction was on the lenient side. Bretherton, which was quite a notorious case, was guilty of 70 acts of sexualised conduct, including sexualised, inappropriate, unwanted touching, kissing, conversations, messaging, involving 3 women aged between 18 and 23 who were legal apprentices or trainees, and the conduct was quite outrageous, and he was struck off. Smith sent thousands of inappropriate sexually motivated messages by WhatsApp. He was a senior member of staff abusing his position vis-à-vis a junior member of staff, and that earned him a strike-off. And finally, Asharaf, a senior solicitor in a position of authority, was guilty of 2 instances of sexual touching, several regular and persistent instances of non-sexual touching over a 2-year period, and using an unwelcome, heavily innuendo-laden remark, all of which earned him in the first instance an internal investigation. It was only after the conclusion of that investigation that the matter was reported, the complainant having tolerated the position for as long as she had, full fear of rocking the boat. And as we sort of said earlier, this is always going to be a problem when it comes to reporting issues, which is where the victimisation point comes in. And the SDT suspended him for 12 months. And those are the cases that bring us virtually bang up to date with what the SRA and SDT are doing about cases involving incidents in the workplace. The sexual misconduct cases are always likely to be seen as the most egregious ones, and currently, and certainly the current evidence is that they are the ones coming up time and again before the SRA and the SDT. It does seem to me, however, that the strength and relative clarity of the workplace environment guidance that we've been looking at this morning is now such as should encourage practitioners to call out bad behaviours of many other sorts to a far greater extent than we've become used to in the recent past. And that would be no bad thing. And that's your lot. Thank you. We've probably got a couple or so minutes for any questions that I will be unable to field. Hello.
I don't know if you can hear me on this.
Yeah, it's just for the recording.
It's just for the recording.
Right. We need to speak up.
So firstly, I just wanted to check all of these obligations apply to in-house solicitors
Yep.
as well?
Yep.
Yeah. And then the main question was, you mentioned that interesting case where you lost at the employment tribunal, and then but still should have reported to the SDT on the base, even though they ended up deciding
Deciding it the other way. Yeah.
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 So what if you win at the employment tribunal? Have you still got an obligation to report it on the basis the SDT might disagree with the employment tribunal?
Well, you won't. If you win at the tribunal, the fact of the tribunal judgment won't give you anything to report because you've won. However, there's the preceding complaint that has gone to the tribunal, which may, depending on the seriousness of the complaint, be reportable.
Thank you.
Yes.
Yeah, can I ask one? The sexual cases are bad.
Yes.
What about bullying, which is just sort of normal?
Well, yes. I mean, I think probably the thrust of what the SRA are up to is to try to denormalise bullying.
That would be great, but in the meantime, older blokes have been bullying juniors for so long that if everyone reported them, the SRA would grind to a halt.
Well,
So when do we report?
you report when the threshold of seriousness, which has a part subjective, part objective element to it, is passed. If the reality is that you're occasionally spoken to sharply by a senior member of staff in an effort to ensure that you do what's required of you, or you unfortunately got something wrong and so forth, that's unlikely to cross the threshold. If it's constant pressure that makes your life a misery, then it is reportable. It is. There's a very fine line. Yeah, no, I agree. And of course the problem is that depending on your position within the firm, you don't want to rock the boat because of the rock and the hard place that I identified in the Emily Scott case. It's very difficult, and there's no right answer to it. Yes.
May I ask about where you
Not
think...
not until you've got the microphone.
May I ask about where you think the SRA and SDT are going to come up with on unreasonable workloads or targets in the context of a profession that has workloads and targets that may be rather different to the general population? And what is a wholly unreasonable workload and target as opposed to this unreasonable workload and target?
Well, who was it? I can't remember now whether it was Savani James. Yes, it was Savani James, wasn't it? Who was written to by her senior partner saying, your targets aren't being met, so you're staying late tonight, you're working all weekend, and you can forget about your bank holiday. And this was a regular thing. And indeed, that same firm was subsequently taken to the employment tribunal by a partner who was complaining about somebody called Mrs. Clifford, who was also complaining about the practices. The importance, I suppose, of the fact that we're speaking about a regulatory context as opposed to a litigation context, is that the judgments are most likely to be applied by people within the profession who actually understand that the profession does have pressures from time to time, and that pressures from time to time aren't of themselves going to be amount to a problem. It is if unreasonable demands are persistently made, and the culture within the firm is one of utter misery, that the SRA and the disciplinary tribunal thereafter are likely to be interested. But I mean, I think that the short answer to your question is that just as judges on appeal say the SDT is a specialist tribunal and understands the profession better than we do, then we have to trust as best we can the SRA also to look at the profession with that knowledge of how you actually work, how we all actually work. So, I mean, that's there again. There's no right or wrong answer, but I think we have to understand that our regulators are going to have some inside appreciation of what it's like to work in the profession. Anything else? probably the last one, because I think the next door.
I was interested in the definition of the counter-inclusive misconduct. I don't know
Yes.
if I wrote it down correctly.
Right.
It struck me when I read it on the screen, and I know for sure, that it could in fact apply to anybody at all, and therefore was a little bit tricksy.
Let's see if we can find it. Conduct which intention
Denies people opportunities because of their background or characteristics.
Yeah.
So, you know, I'm a white public school, Oxbridge, you know, I'm not, but, you know.
Well, let's assume you are.
Or, you know, anybody, and everybody, you know, well, that's, you're just doing that because I came from, you know, Upper Regis.
Yep. Absolutely. I think
Or it's just, it's absolutely
it's
ridiculous.
well, it's very broad.
But it's so broad.
But
It doesn't exclude anybody.
But what it does do, though, is that it prevents anyone, be they white, Oxbridge educated male in their 60s or whatever it may be, being treated unfairly because of their characteristics. In the same way, for instance, taking a completely different type of example, that schoolboys from Eton are now finding it difficult to get into Oxbridge. It's the same principle. They are
being discriminated.
They're being discriminated against. I don't want to get into political debate about that, but it's the same type of thing, and that's why it's defined broadly in that way. It is to cover anyone who's treated unfairly.
Seems to me quite unhelpful in a way.
Mm.
But anyway.
Okay. Well, yeah. I don't know. I don't regard it as helpful. I mean, I think its breadth means that people will be scrutinising. The idea is that firms will be scrutinising their internal procedures more carefully and making sure that everyone is treated fairly and equally. So there we are. Okay, well, anyway, there we are. Thank you very much for coming along. And I think there's more coffee and goodness knows what else. And the next one will be starting in here very shortly.